Welcome everyone to another thought-provoking session in the Working Group 1 Theory Seminar Series of the Cost Action of K-Peritia. WG and I are delighted to have you join us today for an important discussion on cultural expertise on extreme speech cases.
Absolutely, Dina. Our ongoing exploration of cultural expertise has revealed its crucial role in addressing complex legal and social issues. Today's seminar offers a deep dive into challenges and dilemmas associated with applying cultural expertise in litigation concerning extreme speech.
That's right. We are honored to have Max Steuer with us, an expert whose work critically engaged with the intersection of law, cultural expertise, and freedom of expression. His presentation will explore how extreme speech cases demand a contextual, sensitive, and methodologically informed approach to cultural expertise.
One of the key challenges in the field is ensuring that cultural expertise not only informs legal processes but also respects the complexities of free speech and the cultural context in which it occurs. Max will guide us through these intricacies and dynamics, shedding light on both the importance and the limitation of cultural expertise in that area.
Exactly. His insight will encourage us to reflect on the evolving role of cultural expertise in extreme speech litigation, particularly in the Slovakian context, and how it can be applied in a way that is both ethically sound and practically effective.
We are looking forward to sharing with you a stimulating discussion that will push us to think critically about these pressing issues. Thank you all for being here, and without further ado, let us turn over to Max for his presentation.
A presentation on how to link cultural expertise with litigation in extreme speech cases, which, however, as you will see, I will try to argue opens the door actually for larger questions that are also tied to issues of democracy and issues of fundamental rights. I apologize, there seems to be some kind of a problem with the camera. Okay, so what I will try to do in this next, hopefully not too much more than 25 minutes or so, is to first discuss the very notion of extreme speech and how it can be and perhaps even usefully linked to the concept and theory of cultural expertise. In the second part of the presentation, I will try to introduce you, and especially since I think there are some experts on the subject in the audience, but perhaps also some who might be listening to this later for whom this is a more introductory subject. So introduce you some cases where we see this intersection between cultural expertise and extreme speech, one coming from the UK and one coming from the jurisdiction with which I am most familiar with, and that is the jurisdiction of Slovakia. On the basis of these cases, in the third part, I will try to highlight some particular difficulties related to cultural expertise in extreme speech cases and avenues, potential avenues to mitigate these difficulties that perhaps go beyond cultural expertise in some other areas, but I'm very much open to discuss this with you also, because this is, I think, the first seminar in this series of the working group which discusses cultural expertise in what we can say a specific area. We had a first presentation on cultural expertise in a specific region, and then we had a more theoretical conceptual presentation by Professor Holden. So perhaps this can also be a start for discussing how some of these difficulties play out then in other areas than extreme speech. And exactly that is what I will try to raise also in the final bit of the presentation by noting particularly a broader linkage, which I think the area of extreme speech is particularly helpfully pointing to between cultural expertise and democracy, and ultimately even between cultural expertise and knowledge generation in itself. So this is something that I will just briefly try to do at the very end, and please don't hesitate to then also ask any questions and raise your comments. I should also say before going on about my positionality, I'm primarily an academic, but I was involved also in one extreme speech case. In fact, in the case which I will discuss with you, one of the cases that I will discuss with you later on. So when it comes to the first part, trying to link extreme speech and cultural expertise, of course, a good approach, particularly in law and many other disciplines, would be to start with a definition. But here we immediately run into a problem when we try to define extreme speech, and that is because it is really a difficult concept to work with in a sense that what is extreme, and this is an attempted definition that comes from my chapter in the volume edited by and put together by Livia Holden on cultural expertise and extreme speech, that this concept of the extreme in itself is very vague, is very imprecise, and is very much subject to interpretation. So Hare and Weinstein discuss how extreme speech has been defined in some societies, communities, and you may know this particularly if you are familiar with the US notion of clear and present danger, how it has been conceived of as a clear and present danger to societal values. However, what we are running into here is, first of all, what are these societal values? And these societal values may differ. How do they differ across jurisdictions and across various communities? In particular, keeping in mind that such litigation in so-called extreme speech cases may not necessarily unfold in democratic regimes only, where there are independent judiciaries, but it may unfold under circumstances in which what is considered to be, and this leads me to discussing this very notion of the extreme a bit more, what is seen to be desirable, optimal, perhaps even normal, is actually something that is very much out of sync with what, for instance, some established theories of democracy would consider as essential. Commitment to fundamental rights, commitment to free speech. If you have an authoritarian regime, then the legal framework may create a system in which what is normal is to just revere the political leader, and whatever kind of criticism of that political leader would be seen as something extreme. Now, this is, of course, a major problem then for litigation in extreme speech cases from the perspective of cultural expertise, which is inherently linked to some degree, at least, of respect towards fundamental rights and dignity. So that is also why actually the presentation and the research so far that I have done is really restricted to, at least in broad kind of minimalist terms, democracies. And once we were to extend it to regimes that don't meet those criteria, we would probably face even more difficulties than already with the definition of extreme speech. Now, again, I apologize for the camera because there seems to be some permanent problem with that in this Zoom link. But what seems to be the case then is to try to ask, well, what alternative terms to extreme speech may we use? And the bad news is that, well, it is not really helpful to use different terms because they don't make these dilemmas that I just mentioned to you with respect to the notion of extreme in extreme speech any easier. So offensive speech, hate speech, or dangerous speech, hate speech among them being the most frequent one that is invoked, it's not helpful because it is even raising a lot of issues that go into the notion of psychology. What does hate mean? How to conceptualize hate, particularly in the context of litigation? And if anything, then these concepts are even more difficult to pin down than extreme speech, where you at least have this dynamic of the extreme and the normal, which is very much contextual and requires contextual analysis, but at least gives some basis for such an analysis. So that is why I tend to use this notion of extreme speech, with some exceptions that we may discuss. Now, moving on to linking cultural expertise to extreme speech. And of course, cultural expertise has been defined by Livia Holden, and I think most, if not all, participants of this call are very well familiar with that definition, so I will not elaborate on that. There is also the seminar that was preceding this one in the series, which I recommend for that purpose. But when applied to extreme speech, it means, in my reading, cultural experts as assisting decision makers with comprehending the speech acts in question and their context. So it is precisely in providing this context for a speech act which is under assessment, or a broader set of speech acts, where the cultural expert comes in. And this requires, of course, understanding local discourses, but I would argue it also requires at least some exposure. I don't want to be very restrictive here in conceptualizing it, but at least some exposure to global scholarship on the role and impact of speech acts, and on the notion of freedom of speech in itself. This again doesn't have to provide any barriers in terms of the discipline, and I might get to that at the end of the presentation, or in terms of the previous educational background, but it provides some restriction in terms of the subject matter, which I think is helpful then for the cultural expert to be able to address these dilemmas associated with litigation in extreme speech cases. Now, we could also discuss how the notions of procedural neutrality and critical affirmation that have been identified as essential in Holden's conceptualization of extreme speech play out here. Very briefly, this is something for longer debate, but it may mean that even though a cultural expert would typically be geared towards protecting human rights, protecting the vulnerable, protecting those, or standing up for the voices of those who may have been marginalized. In the context of litigation of extreme speech, sometimes this may, in order to be able for the expert to provide this analysis, it may need to recognize also the free speech rights of an extreme speaker. And this can be, of course, very difficult from a perspective of a citizen or an individual, but I think from the perspective of the culture expert, it is very important to recognize also that there is a free speech claim, and there are theories of free speech which say that any kind of legal restriction on free speech is illegitimate in a democracy, and there have to be other tools than legal regulation, than legal proceedings, than litigation to address the issues and the harm and the damage that is caused by some forms of extreme speech. So from that perspective, even the extreme speaker, even if clearly identified as such, has that free speech right. And I think this balancing is entailed in procedural neutrality. So this was for the association between cultural expertise and extreme speech. Let me now move on to the segment where I would like to bring in some examples, some cases where actually we have seen, I think, the manifestation of cultural expertise in extreme speech litigation. And I typically open this with this image of the Greek myth. Some of you may know Scylla and Charybdis. So this very narrow pathway that the sailors need to take between two very dangerous positions. And sometimes that may be a little bit of an analogy of what a culture expert faces in, well, not necessarily only extreme speech cases, but that is the scope of my presentation. So that is where I'm highlighting this connection. So the first case, just very briefly, this is a well-known case, comes from the United Kingdom, and it is, we could call it a so-called Holocaust denial case because it revolved around, first of all, there being a historian, or at least a self-proclaimed historian, we could specify that way, David Irving, who has written very controversial statements about what has happened, including in the Second World war. And in response to those writings, another expert, Deborah Lipstadt, has accused Irving to be a Holocaust denier in her book, in her writings. And actually, and this is a kind of not a typical way of how these extreme speech cases, from what I have seen so far, unfold, but it was actually the one who was accused of being a Holocaust denier, so David Irving, who sued Lipstadt because he claimed that he is not a Holocaust denier, and therefore his reputation is undermined through Lipstadt's book and Lipstadt's writings. So actually the party that was standing up for free speech, or for more robust free speech, was the party that also was highlighting some elements of extreme speech in Irving's, in the other party's claims. And where did cultural expertise come in here? Courts needed to understand whether Irving in fact was a Holocaust denier, whether this claim can be factually upheld in light of particularly historical evidence. And that is where historians were invited to join and to provide expertise in the case. Most prominently of them, Richard Evans, a Cambridge historian, who also is a prolific writer and who has also written a lot about his experience in this trial, which is actually helpful for studying the case, because otherwise it's quite difficult to access data related to these types of cases. The case was also complex, of course, because Irving has written a lot. There was a lot of historical research that needed to be done. It also received a lot of coverage because of the high-profile actors involved in it. In the outcome, Irving lost the case because, based on precisely the historian's work of Richard Evans and his team, it was convincingly demonstrated that indeed Irving has distorted historical facts about events also in the Second World War. And so the claim that he is a Holocaust denier is a plausible claim that can be upheld. As such, of course, Lipstadt is well within her rights to write about it and to communicate about it. And typically, in this case, the historians are seen as being essential for the outcome. But also here, you don't have a disconnect, because free speech was protected through the judgment, but also the historian's contribution and the culture expert's contribution has contributed to the standards of free speech. Now, what I've seen so far, the more typical type of cases, but I'm also wary of generalization, because, as I said, there's much more data that would be needed from other jurisdictions to be able to make comparisons. But the more typical type of cases, it seems to be, is when it is the opposite, when the cultural expert is more geared to be invited or to be called to provide testimony that in the outcome at a certain level leads to restriction of freedom of speech or sanctioning of acts of extreme speech, not through there being public criticism, Lipstadt accusing Irving in a public writing, but through the means of law, and in particular through criminal law. And now this has been very much the tendency in Slovakia after the 2016 parliamentary elections, when an extreme right party has made it to the parliament. And so the statements of politicians of this party have also become more present in the public sphere. There is a criminal legal framework in Slovakia which restricts speech in the name of protection against defamation of nation, race, and belief, and a number of other grounds, which of course raises the question then whether particular speech acts, for instance, by these extreme far-right politicians, amount to extreme speech, which needs to be, as a result of there being a legal regulation, restricted, prosecuted, and sanctions need to be issued. So this is where the opening for the cultural experts arises, that they are invited, they are called to comment on the speech acts and to provide the contextual analysis of the speech acts. Now, there are some different kinds of proceedings as well, and there are also other experts within the K-Peritia network who can comment on that. But this is the one type that has been prominent, at least for a couple of years, in Slovakia. And I'm raising this one case. There are similar cases as well, but this one case of the far-right politician Milan Mazurek, because this is the case in which I was also called to be one of the experts. I was called by the police, and later I also attended a court hearing. Now, there are some procedural specifics that also are important at some level, but for the sake of time, I will try to focus on what I think helps us understand and appreciate some of the particular difficulties of culture expertise in extreme speech cases. And this is that again here, although perhaps not to an extent as in the UK case, we have seen mediatization of proceedings, meaning that there was media interest in the case because this was a member of parliament at the time when the case was unfolded. And it was also an important case in a sense of it being one of the first cases of the type, because before, for various reasons, the police was reluctant to prosecute these or to initiate proceedings for these kinds of acts of speech. So what has happened? And you know, those who are interested to delve into in greater detail, because I don't have time here, there's just an article that was published 2 weeks ago in also a collection that is edited by Livia Holden. So I'm happy to share it with anybody who is interested. Feel free to reach out to me, which also has a theoretical framework that I will not delve into here. But let me guide you through a little bit the facts, perhaps, of the case and the outcome, and how this points to some difficulties in culture expertise in extreme speech. So the type of speech that was uttered by the far-right politician, I will not read it out. There is some more information in the slides. You can consult as we go along. But was essentially an act of anti-Roma speech. So the Roma minority is one which has been historically and still even contemporarily discriminated against, including in Slovakia, and often far-right politicians have used the Roma as a target for their speech in order to get more votes, to get more support. So there was this act of speech. It also links to a range of other speech acts that were uttered before by the same individual. But in this case, there was a criminal proceeding that has started. And so the police has invited, in this case, me, but this could be this is a general trend. The police may invite expert witnesses to provide a contextual analysis of this speech act in the background of the broader set of speech acts that were initiated by this far-right politician. So here I reproduce, and this is also in the article I mentioned, the questions that I was asked as an expert witness. Particularly controversial was the third question, because in this one I was asked to analyze the content and form of realization of the speech with reference to the right to freedom of expression. Why was it seen as controversial by some, not only commentators, but also academics? This debate is still going on. It was seen as controversial because there is this idea that cultural experts should not deal with the law. They should deal with the questions of fact. And this seems to be coming dangerously close to dealing with the law, because freedom of expression is also a legal right in the Slovak constitution. And even the question, I didn't put it in entirety, but made a reference to the European Convention on Human Rights, to Article 10, right, to freedom of expression there. So the controversy arose whether this type of question can be even asked from a cultural expert. And my argument is yes, because in this case of extreme speech litigation, we cannot separate the contextual analysis from the legal regulation, because the legal regulation has societal effects. So the culture expert is not providing a doctrinal analysis of legal regulation, of course. That is not the purpose and role of the culture expert. But the culture expert needs to account for the societal effects of the legal regulation. So, for instance, the likelihood of other types of responses, and there is research by others, which I used engaged with a review of scholarship, among others, in my expert statement, that shows that whether there is a criminal legal framework in place in the given jurisdiction affects the propensity for other types of responses by the society to acts of extreme speech. So then it cannot be entirely ignored what is the legal regulation, even though the analysis is a contextual one and it is not a doctrinal legal one. But this is a controversy that is still to some extent alive, and I would be also interested in hearing your thoughts on that. So it's one of the difficulties that I think not only arise in this case, but arise more generally with litigation in extreme speech cases, at least in some types of extreme speech cases, how to incorporate legal regulation, but without over blurring this boundary between law and fact, which some judges and some legal professionals take very seriously, and then it may understandably upset them if they seem to be seeing that the cultural expert is crossing that boundary. However, there are other difficulties very briefly associated with, I think, not only this case of the Slovak far-right politician, but also more generally, and that is that there is a potential interest of such high-profile party in the dispute, not necessarily to primarily win the case. So in this case, winning the case would be that they would be acquitted. They wouldn't be convicted for extreme speech. But that may not be the primary goal. The primary goal may be to use the proceedings to get media attention and then to hopefully for them also get more votes, get more public support. And they might be ready to negotiate a loss in the case, particularly if the penalty is not very severe, in exchange for this rise of public support. And this is what I argue in the article. I welcome, of course, counter arguments, but this is what happened in the Mazurek, the Slovak case that I mentioned. So it became less important for the party to be acquitted than to mediatize the case along their own terms. And this mediatization entailed certain accusations of personal bias of the cultural experts. So in this case, it was myself, but other cultural experts have faced similar kinds of accusations in Slovakia and other jurisdictions that have had nothing to do with the content of the testimony. And the content of the testimony was almost not discussed at all in the public debate that surrounded the case. So the media reporting, the public reporting about the case was almost exclusively captured by the narrative or the framing of the far-right actor, who focused only on the accusations of personal bias. And we can discuss this in the Q&A if you want to engage with it further. But the main point is that it actually didn't help the quality of the debate, at least that surrounded the litigation. Now, of course, the testimony was still included in the case during the hearing. But what got out of it, what reached the broader public was really much less linked to the contextual dilemmas associated with regulating extreme speech and assessing speech acts. So this is where I think a particular difficulty arises with the extreme speech litigation, especially in case of these high-profile partisan actors, and there are more issues that can be raised in this regard. But this is one point that I would like to share with you at this level, right? So how now to address this problem of the possible personalization and partisanization, perhaps, of cultural expertise at the expense of there being a meaningful debate on the content and legitimate challenges, perhaps, to the content of the testimony. So this is not a highly developed recipe, but some suggestions that may go in that direction is, first of all, well, to improve public understanding of culture expertise, not only academic, but also the public sensitivity, recognition of what is the role of culture experts, how does this kind of contextual analysis unfold, why is it important, what can it tell us? Media training and media sensitization combined with transparent rules, also an expert participation. So one problem I personally faced when I was an expert in this case is that I could not really comment to the media. The media, well, some media have asked me to give an interview or to give a statement, but I could not because it was still an ongoing case, and according to the Slovak regulation, it is not allowed to bring up facts, at least beyond a certain very basic level, which is not really helpful. So in this case, actually, my freedom of speech, you could say, was constrained, and the other actors have also not emphasized that much the content of the testimony. So a recognition of the importance of the content in such cases by the media, but also perhaps to a little bit more freedom, and this would require then comparison across jurisdictions of culture experts to comment on these cases, on these ongoing cases, to share what they have provided in their testimony could mitigate some of the challenges mentioned. There is also an issue of lack of culture experts, especially in small jurisdictions such as Slovakia. And the benefits here could be to initiate proceedings that are more flexible, that allow to bring in more experts and also facilitate collaborations between experts. Because, for instance, in this particular case, there was a cumbersome way to potentially get some other experts on board, but otherwise, it was quite often a single expert featured in many of these cases. And then, well, the outcome, as I have hinted at already, of this particular Slovak case was that the far-right politician was convicted. They lost their mandate, but in the next elections, which took place incidentally shortly after the ruling was affirmed by the Supreme Court with some small changes, they have regained the mandate with an even stronger electoral support. So that provides some anecdotal evidence that the trial at least didn't seem to directly hurt them in terms of public support. And this is also a dimension that comes in perhaps even to the level of judicial decision-making. I think I'm running out of time, so I will just wrap up with two general implications that I think this broad debate on cultural expertise in extreme speech litigation raises. So one I already hinted at with reference to the fact that I'm focusing only in this analysis and broadly speaking democratic regimes, and that the notion and the problems associated with extreme speech in regimes which don't meet certain standards, this is of course very difficult also to determine, of democracy, may be very different and even much more challenging. I think it would be very fruitful to collect more data, to have more insights into the operation of litigation in such cases also in diverse jurisdictions, but especially along this regime variable, right? So whether and to what extent regimes are democratic or not. I think there is still a strong normative argument for the potential of a democratic regime to be more welcoming, to be more inviting towards cultural expertise, as per Holden's definition, because this inherent association, at least at some level, in my understanding of cultural expertise, with the protection of rights, with the protection and at least recognition of minorities is there, and is much more difficult to articulate in an authoritarian regime. Lastly, one of the challenges that pertained in the Slovak case on my personality was my disciplinary background, that I've studied, different disciplines. I've not had a clear pathway of either being explicitly labeled as a political scientist or explicitly labeled as a sociologist or an anthropologist, but I had degrees from a variety of fields. And that was seen as, or claimed to be seen as, weakness, because you have to categorize yourself into a particular discipline. I think this is very dangerous for cultural expertise to think in this way. And of course, this network doesn't think that way, because as Anna mentioned at the beginning, one of the aims of this network and the working group in particular is to use an interdisciplinary perspective, so to go beyond a single discipline. However, where I would like to perhaps raise some questions, and this may also go beyond the scope of today's seminar, because I know there will be further seminars going ahead, is whether we need something even more or perhaps different than an interdisciplinary insight, which still requires, in my reading so far at least, first of all, to categorize everybody into a certain discipline, and then to collaborate, which is very helpful and valuable, also with respect to extreme speech cases. So there are notions of transdisciplinary approaches which try to intensify those collaborations, but perhaps even this network and the working group and the debates that are to come may show that the very notion of disciplinarity is something that needs revisiting, or at least needs to be interrogated. To what extent the fact that everybody, first of all, seems to have to categorize themselves into a certain discipline may be already in itself limiting. And for example, for a small jurisdiction such as Slovakia, in extreme speech cases, may also lead to not using the potential of expertise that is already out there, but that faces difficulties with this kind of standard categorization into disciplines. So coming back to, and this is the final slide, to extreme speech more specifically, I think, and I've tried to show that this is an emergent area where there is a lot of potential for thinking about the interaction with the theories and concepts of cultural expertise, but the data so far are insufficient to derive any more general implications, and I have not even attempted, and I wouldn't want to attempt to do that just on the basis of the cases I've studied. So that is where also definitely space for collaboration may arise. But in addition to empirical studies, I think there is need for more theorizing, particularly on this interaction between cultural expertise and political regimes, particularly in extreme speech contexts, and ultimately cultural expertise and knowledge generation. So that's it from my end. Thank you very much. Apologies for the camera issues, and I greatly look forward to your comments and questions.